All right, so on September 17, 1787, the founding fathers signed the U.S. Constitution that went into effect in 1789. Today, we have with us Julie Suk and Irving Kagan. Julie Suk is a professor of sociology, political science, and liberal studies at the Graduate Center of the City University of New York, where she serves as the academic dean overseeing interdisciplinary master's programs. She is also the Florence Roberts Visiting Professor at Yale University, Visiting Professor of Law at the Yale Law School. Prior to the Graduate Center, she was also a professor for 13 years at Condozo Law School in New York. We are here today to discuss her new book, We the Women, The Unstoppable Mothers of the Equal Rights Amendment. She's also an author of dozens of law reviews, articles, and book chapters. We also have Irving Kagan with us, who has taught courses in history, constitutional law, international relations, and philosophy at Hunter since 1991. And as he noted, a lot of his former students are present. He has served as an advisor to the Washington Seminar, the GO, What's What, and the Hunter Model United Nations Society. I'm going to give the presenters over to you, and we're going to have a couple of minutes in the end to have your Q&A. We have also received some questions ahead of time, and if you have some immediate need to feel that you want to pose your questions, you can pose them in the chat, but we'll have a couple of minutes in the end to ask your questions directly if you wish so. Over to you.
Okay, well, I want to thank you, Anika, for your work in setting this up, and the Alumni Association, and Julie for including me in this wonderful opportunity to interview her. We worked together many years ago. She has come and visited my students in my class as she was sort of working out some of the different elements of this book. So again, I'm just honored to be included. I've always dreamed of being a talk show host. So this is, my aspiration. You've made my dream come true, Julie. I have the book right here. Oh, I guess it comes out mirror image, but it's We the Women, the Unstoppable Mothers of the Equal Rights Amendment. And I guess I just wanted to, this is a 100-year history you provide for us, and you provide like an extraordinary several generations of characters of women who I think at various points you sort of say each one was sort of standing on the shoulders of the previous one. But maybe we should just start at the beginning. What was the ERA? What did the authors of the ERA, why did they think it was necessary? Why was it proposed in the first place?
Great, well, thank you so much. And before I answer the question, I just want to thank Aniko and the Hunter College High School Alumni Association, and particularly Irv Kagan for coming together for this event, and everyone in the audience. I'm particularly excited to be here with Irv Kagan because one of my fondest memories of being introduced to the Constitution was through our visit to the Supreme Court in 1992. We went on Washington Seminar, and I know that many others perhaps in the audience have participated in Washington Seminar. And we went to the Supreme Court, and we met with one of the clerks for Justice Kennedy, and Justice Kennedy even made a cameo appearance. And it was a tense term of the court in 1992 when Casey was decided. So it was a moment in history when women's rights, and particularly reproductive rights, and the future of Roe versus Wade hung in the balance. And some might say we're in a similar moment today, a generation later in 2020. And today, a generation later in 2020, I mean, one thing we didn't talk about when we were at the Supreme Court, and I think one thing that happened without much mention and without even my awareness in 1992 was that it was the last time that the US Constitution was actually amended. In the spring of 1992, the 27th Amendment to the US Constitution, which is the last amendment we ever had, was added to the Constitution. And that amendment was actually written by founding father James Madison himself. And of course, it's the founding fathers that we commemorate today on the day that in 1787 that the US Constitution was signed and sent to the states for ratification. So this is kind of a long and personal and winding way of bringing us back to Irv's question about what the ERA was. Because the ERA is an amendment and is currently poised to become the next amendment to the US Constitution, notwithstanding various procedural hurdles. And it has this long history, much like the 27th Amendment, at least 100-year history. So the ERA is a proposed amendment to the US Constitution, which guarantees equal rights without abridgment on account of sex. And it was an amendment that the women's movement got behind just shortly after the Women's Suffrage Amendment was ratified in 1920. So it was first introduced in 1923. The text of the amendment, which was changed a little bit from the time of introduction in 1923 and the time of actual adoption by both houses of Congress in 1971 and 72. The text says equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. And it was adopted by Congress in 1972, and the states began to ratify it. It did have a time limit on ratification that Congress imposed, which once got extended, but even with the extended time limit, the amendment was only ratified by 35 states, when under Article 5, you need 3/4 of the states, which is actually 38 states, in order to make a constitutional amendment. And the ERA has come back into the news now because some states, 3 states since 2017, have continued to ratify the amendment, bringing the count up to 38 states as of the beginning of this year. And what's interesting about the amendment, of course, is that at the time that it was introduced in 1923, there were forms of sex discrimination in the law that its framers really wanted the amendment to eradicate. Some of those discriminations in the law were in fact eradicated between 1923 and 1972, but even in 1972, when both houses of Congress adopted by overwhelming majorities to, voted by overwhelming majorities to adopt the amendment, there were remaining sex discriminations in the law, and the Supreme Court had never recognized sex discrimination as a problem under the Equal Protection Clause. So it was adopted then to solve certain problems, and even when the ERA wasn't fully ratified, some of those problems were resolved through litigation under the Equal Protection Clause. So today, in 2020, some of the reasons given for ratifying the amendment today have also evolved and changed to meet some 21st century concerns about gender inequality under the law.
And back when it got started, it came right on the heels of the 19th Amendment, which was going to give women the vote. Why wasn't that adequate to the problem?
So I think that many suffragists, I mean, the suffrage movement, and if you think about what's required to amend the Constitution under Article 5, you need 2/3 of both houses of Congress and 3/4 of the states. So obviously to get an amendment, there had to be a lot of coalitions across different visions of why women needed the right to vote. And at least some of the suffragists believed that it was not just a symbolic thing that women could be respected as full and equal citizens if they had the vote. They actually wanted to use the vote to change other laws that they felt kept women down. And some of those laws included married women not having equal access to property rights. So even if a married woman worked outside the home, she may not necessarily own her own earnings. Married women did not have equal parental authority over their own children. So that's why they thought that another amendment was necessary. Just get rid of every other form of discrimination beyond the right to vote, which was part of the suffragist agenda in the first place.
And I think a lot of people know, especially most recently from watching Mrs. America, about conservative women, Phyllis Schlafly, opposing the ERA in that period of time. But you tell a very interesting story about how progressives, how feminists did not all agree about the ERA, that there were some opponents to it. So why would a female progressive, a feminist, oppose the ERA in that moment?
So in the 1920s, and I think there are some features of the 20s that might even resonate today, the real fear amongst those who advocated for women's rights and women's liberation was the judiciary. They were not sure what the sitting federal judiciary would do with this amendment, because it just said that women and men shall have equal rights. And one of the things that might happen if you got an amendment like that, given the sitting federal judiciary, was that the judiciary might use it to strike down certain laws that distinguish between men and women in order to overcome women's exploitation in the workplace. So there were laws that actually guaranteed minimum wages to women only. There were laws that regulated the hours of work for women only. And the reason they only included women was that the Supreme Court, since the case of Lochner versus New York in 1905, had been striking down labor protections that were for everyone. And so because of the Supreme Court's hostility to labor protections, some women had had some measure of success in getting labor protections for women only, on the rationale that since women didn't have the right to vote and generally were not represented by labor unions during this time, they needed legislation to actually protect their rights as workers to minimum wages and maximum hours. So the Supreme Court had kind of made an exception and allowed those labor laws for women only, while striking down labor laws in general. And so some of the women who were actually, I think, who we would describe as progressive feminists and who had been advocating for much of their careers, like Florence Kelley, on behalf of working women in industry, they feared that the ERA might be used by a conservative judiciary to get rid of certain progressive gains in the area of labor legislation for working women.
And a lot of the work I know you've done during your career has been about comparisons between constitutions and what we can learn from that. And I guess I'm wondering, you tell that story in the book. How is the record of how women's rights were enshrined in other democracies? How is it relevant to the story of the ERA in the United States? And what sort of protections did women get elsewhere? And did the United States fall behind in that, in that chronology?
So I think so. I mean, even from the very beginning, when the ERA was introduced, there were references in the congressional hearings to other countries that had guaranteed equal rights between women and men. The German Constitution, the Weimar Constitution in 1919 actually had this provision that said women and men basically have the same rights. And of course, after World War II, almost every constitution that was written after World War II in the 20th century, this is something that Justice Ginsburg often points out in speeches about the Equal Rights Amendment and about constitutional change. It became a very common feature of constitutions around the world after World War II to include a provision on equal rights between women and men. And that also becomes an important point in the legislative record in the 1940s, where they point to the UN Charter, they point to all these other countries that have a provision like this. And what's really interesting also is that in the 40s, when this point is made, Mary Church Terrell, who was active in the African-American women's movement for suffrage, and one of the founders of the NAACP and the National Association for Colored Women, makes this point in her testimony in favor of the ERA. She talks about the fact that the Japanese constitution that has just been drafted following World War II has a provision on equal rights between women and men, and the US doesn't have one at that point. And certainly today, if you look around the world, not only do a lot of these countries like France, Germany, Italy, a lot of European countries put a general either non-discrimination clause that explicitly references sex discrimination or a guarantee of equal rights between women and men in their constitutions after World War II. In the 90s, they refined those constitutional guarantees to make clear that the law could distinguish between women and men for the purposes of overcoming women's underrepresentation in matters like politics. That is, in Germany, in France, in Italy, there were a lot of conflicts in recent memory, in the late 1990s, around whether or not you could pass laws imposing gender balance rules, for example, in positions of leadership. And you get these amendments in the 90s and the early 2000s to make clear that a law that allows for gender quotas and gender balance is not a form of sex discrimination. And so there's a lot of 21st century policy innovations that are being legitimized through gender equality amendments around the world. And the United States has not really participated in that part of the global constitutional conversation.
The book is really interesting. You provide a kind of a whole new pantheon of founders. You know, we know about Madison, we know about Hamilton. Now we've got a whole new collection of people who you say we should really be thinking about and know about. I knew about some of them, but not as much as you told me. Can you talk about people who you think are unsung heroes of this narrative, people who, you know, should be the focus of a good American history course, who are not getting the proper credit right now?
So I think with regard to the ERA, one of the things that's most remarkable about it is that adding it to the Constitution now would be adding the only amendment that was made by women, you know, written by women. And these are women who were not part of Congress when the original drafts were proposed in the early 1920s. But by the early 1970s, there are 10 women in the House and 1 woman in the Senate who are active in pushing the ERA forward. And they actually had to take some extraordinary measures because at the time, even though there was growing support for the ERA, the congressman who is the chair of the House Judiciary Committee didn't let it out of committee. So it didn't actually get a floor vote. So Martha Griffiths, who's a congresswoman from Michigan, had to do a discharge petition. She had to actually get the signatures of half the House just to get the thing debated and voted on the floor. And so I think she's a very important unsung hero of the struggle, and not just because of what she did, which is get the ERA debated and passed, but also because of the vision that she brought to the kind of amendment that it was and could be. And that's a vision that she shared with women like Patsy Takemoto Mink. Patsy Mink was the first woman of color to be elected to Congress. She was a Japanese American woman who had lived through her community's internment during World War II. In Hawaii, and she's in Congress in the early 1970s, along with Shirley Chisholm, the first African-American woman elected to Congress. And Shirley Chisholm, of course, is depicted in Mrs. America, and she's depicted as someone who ran for president and failed. But I think it's important to note what these women did to try to get the ERA in the Constitution and the vision that they brought, because it wasn't just that they wanted a new right that was about women. The way in which they talked about the right to equality and the right to sex equality made it more of a 20th and 21st century right. That is, we often think about rights as protections that we have against the government. And therefore, when the Supreme Court decides cases about these rights, the Supreme Court strikes down laws that violate those rights. And that is somewhat what they had in mind. They had some sex discriminatory laws in mind, but more importantly, they saw the ERA as a political catalyst for more transformative changes in American society. And that would take place not simply by virtue of having a constitutional amendment, but by having an amendment that gave legitimacy to legislation. So legislation that Patsy Mink was working on at the time, along with Shirley Chisholm, was Title IX, which was passed in 1972. The hearings on Title IX were going on at the same time as the ERA, and it created a robust protection for equal opportunity in the educational context. Shirley Chisholm and Patsy Mink were also working on the Comprehensive Child Development Act, which got actually tremendous support in Congress, but was vetoed by Nixon. But the Comprehensive Child Development Act would have created federally funded and supported childcare centers throughout the country so that every child would have access to childcare regardless of ability to pay. And they believe that access to childcare was as important as non-discrimination to making equality real for women, whose inequality was largely the product of expectations around women's role in childbearing and child-rearing.
So they're founding mothers, parallel to founding fathers, but maybe the mothers part is a very important part of this story. And so you've given us a sense of what was on their mind, and maybe what they were putting into the congressional record. Again, maybe this is the story of a lot of enthusiasm as they get it through Congress, and it seems unstoppable, but then of course it was stopped. And can you give us a sense of how that happened? I can remember actually as a child reading Doonesbury, and there was a whole long series of a character named Joni Caucus going to debate Phyllis Schlafly, who would not appear in the comic strip, but she was sort of a terror an invisible terror in the Doonesbury cartoons. What happened?
So I think it's actually very complicated what happened. One conventional narrative, and I have to admit that when I was in high school, Phyllis Schlafly was probably the only name that I knew in connection with the ERA. And I think that is evidence of the conventional narrative, which I think is also depicted in the TV show Mrs. America, which is that Phyllis Schlafly kind of single-handedly created the Stop ERA movement by convincing American women that they did not really want this ERA because it would be terrible for mothers, that it would take away privileges that women already had based on their role as mothers and homemakers. And that is an important part of the story, that certainly she and her movement, the Stop ERA movement, proliferated the misunderstanding that the ERA would lead to such a rigid form of gender neutrality in all matters, no matter what, that there would be no opportunity, for example, for laws that try to give protections to women based on their underrepresentation or lack of access to power. So there was a misunderstanding that she proliferated. But one important aspect of the story that I think does not get enough attention, which I really try to draw out in the way I tell the story in my book, is the extent to which the movement, the Stop ERA movement, was actually facilitated by political structures that preceded the movement. So what I mean by that is the fact that the ERA, despite growing support, doesn't even get a debate on the floor of Congress because a man who has a lot of control over what gets heard, the chair of the House Judiciary Committee, Emanuel Seller, stops it from actually getting debated. Similarly, once Congress votes by overwhelming majorities to actually adopt the ERA after having a real debate, enabled by a discharge petition that Martha Griffiths instigates, even when you have that, in the states, the Constitution does not require any of the states to consider an amendment adopted by Congress and proposed. And so what that meant is that there was a lot of stalling, and men who controlled committees at the state legislatures, even while there was growing support for the ERA, could stop the ERA ratification from being debated by the full body of a legislative chamber. And that's what happens in Virginia for a good part of the 1970s. And it's an important part of the story, because if you have a ratification deadline and you have state legislative committees, just a handful of people saying, you know, let's not hear this time around, maybe another time. It's a way of kind of rejecting the ERA without fully taking public political heat for rejecting the ERA, because there's no debate, there's no recorded vote. All you know is that other priorities got heard that term, and this didn't. And I think that, and then in Phyllis Schlafly's state, there's also the fact that legislatures have tremendous control over what they do with federal constitutional amendments. And in Illinois, they've always had this rule since the 1970s that you need 60% of the vote to ratify an amendment. Most state legislatures just do a simple or constitutional majority vote, but the Illinois legislature required 60% of the vote. So that created a much higher hurdle for ratification of the ERA. And when the hurdles are that high, it's very easy to win by confusing people. And that's exactly what Phyllis Schlafly did, right? If the bar is 60% of the vote, and there are mechanisms by which debate is prevented, raising some doubts and creating some confusion is actually a pretty effective way of making sure that the amendment is stopped.
So, and you mentioned deadlines, and you mentioned how the deadlines have been, an argument has been made about sweeping them away in recent years. Can you tell us a little bit about why those deadlines seem to kill the ERA and the arguments for why those deadlines and those lapse deadlines are maybe irrelevant in our argument today about why we can resuscitate the amendment?
So deadlines on ratification were never used before the Prohibition Amendment, but the Prohibition Amendment, which was adopted right before the Women's Suffrage Amendment, had a deadline, and that deadline was actually part of the amendment itself. And it said that the Prohibition Amendment would be inoperative unless ratified within 7 years. And the opponents put that in. But because they did that with Prohibition, even though there was a debate about putting a deadline, the 19th Amendment, the Women's Suffrage Amendment, the Women's Suffrage Amendment didn't have a deadline, but basically every other successful constitutional amendment after that did have a 7-year deadline. And so when the ERA was proposed, when Martha Griffiths did that discharge petition in 1970, well over 90% of the House voted for the ERA, and that version that passed in 1970 actually didn't have the deadline, but then it stalled in the Senate. And it stalled in the Senate because very vocal opponents they pretended that they weren't totally against the ERA. They said, well, why don't we put a deadline in it? And maybe we can also put in a little provision that says that Congress can exempt women from military service. The idea was they were giving the impression that they could just change the amendment a little bit to make it better. But of course, the reality of that political moment is that if you change the amendment a few weeks before elections, there would be no time to reconcile the two versions and actually vote on something that would go to the states for ratification. So the deadline became this way of stalling and sending the thing to the legislative graveyard, which is what happened. And the supporters, when they came back in the next congressional session, decided in 1971 that they were going to try to quiet some of the opposition by just putting in that deadline. They were confident that it would get ratified within a short period of time, so they put that deadline in. And so that's the origins of the ERA deadline. That's to say, even though many people think that it's kind of a normal or necessary part of constitutional amendment making, that every amendment has a deadline, it didn't have to be that way, and it was put in by some of the vocal and minority opponents of the ERA. That said, the way they did the deadline, and it's consistent with the way that Congress had been fashioning deadlines for the previous two amendments, the 25th and 26th amendments, they didn't use the same language as they did in the Prohibition Amendment, which says that it'll be inoperative unless ratified within 7 years. The ERA deadline just said that the ERA would be valid when ratified within 7 years. And so you could read that as saying, if they ratify it within 7 years, it's definitely good to go, valid. If it's not ratified within 7 years, it's ambiguous as to what the consequence is going to be. And by that logic, the Congress actually extended the deadline once, and Congress extended the deadline in 1978 on the understanding that because this particular deadline was not included as part of the constitutional amendment text itself, it wasn't part of the thing that 35 states had already ratified. And therefore, Congress, just as Congress has the power to put in a deadline, Congress has the power to change the deadline. And it's by that logic today that at least the House voted earlier this year to remove the deadline altogether. And so if the deadline is changeable, then it could mean that once Congress changes the deadline, now that we have 38 ratifications of the ERA becomes part of the Constitution.
And then there's this further complication that some states have actually repealed their ratification or did it within the few years after they ratified. And then I guess I'll just pose a devil's advocate question to you. Like, doesn't it actually kind of make sense that at least within a generation, we have that strange 27th Amendment, but you know, the whole people are deciding whether to ratify a change to the national basic law. Like, is it kind of, can it just be 200 years of, you know, one state at a time?
So thank you for asking that question. I mean, I think certainly certain scholars like Sai Prakash at the University of Virginia have taken the view that there is an implied requirement in the Constitution, and not just implied by the Constitution, but a strong political theory based argument for synchronicity in the making of constitutional amendments, that even if Congress doesn't put in a deadline, that we should consider somewhat illegitimate the kind of process that we see, even with the 27th Amendment, that you have hundreds of years go by and states ratifying at different moments. And by that logic also with the ERA, that you have 35 states ratifying in the 70s and 3 additional states coming in like 40 years after that, that maybe there's a legitimacy problem with that. And I guess I think that this really goes to fundamental questions about who controls the process by which we change the Constitution, and what is, I mean, there's a lot of debate about whether or not Article 5 is or should be the only legitimate process by which we amend the Constitution. And I think part of the reason that question comes up is that Article 5 was adopted, of course, at the founding. And today's a good day to think about the founding, because at the founding fathers said, "We the people," but it's not, and they didn't say "we the men" or "we the white men," but it's also clear that the Constitution that they wrote did not assume African Americans to be full persons, and certainly not citizens. It's also clear that the legal order, which they took for granted, was one that did not count women as full persons. And so now, and if they adopt a constitution that has a rule, an amendment rule that requires 2/3 of both houses of Congress and 3/4 of state legislatures under conditions where many people who might be subject to the laws of the United States are not actually included in voting at that moment for those who constitute the 2/3 of Congress and 3/4 of the states, that suggests, and this is a question that I think the women at Seneca Falls engaged through the Declaration of Sentiments in 1848. In what sense are women bound by the amendment rule? That is, if they weren't included, they weren't represented at the founding, then is Article 5 the only thing that tells them what they need to follow, right? And of course, even if Article 5 is binding, we could have a narrow reading of Article 5, or maybe narrow reading is not the right word. We could have a reading of Article 5 that is compatible with additional constraints made by Congress on the amendment process, making it harder and harder to amend the Constitution, or easier by either not allowing deadlines or allowing Congress to change the deadlines when appropriate. And also, since you brought it up, rescissions. What happens to rescissions, right? Article 5 doesn't mention rescissions. One theory is that therefore rescissions aren't allowed. Another theory is, again, it's up to Congress because Congress controls the amendment process under Article 5. And rescissions, when the 14th Amendment was passed, some states tried to rescind the 14th Amendment, and Congress did not recognize those rescissions. I think it is a choice that Congress can make, but I think there's this deeper question of how we should think about the process by which we change the Constitution, given that the rule by which we change the Constitution was made under conditions of non-representation of everyone who's expected to be subject to the Constitution.
So I have another question. I'm going to combine it with a couple that came in from the audience. So my question was, you talked about the yeoman work that Ginsburg and other litigators did in terms of using the 14th Amendment to, if not getting us to strict scrutiny examination of laws that distinguish men and women, the same standard that we use for race, at least intermediate or heightened scrutiny, maybe very close to that strict scrutiny standard, in the US versus Virginia case. If that work has largely been done, why do we need an ERA now? And then the questions that came in from our viewers, one was, what would be the single largest impact of the ERA's passage? Like what, and again, versus the current use of intermediate scrutiny, to what degree would women's rights, I guess, be changed? And then another one which said, how does one justify the often necessary legal distinctions between men and women that exist? And would that change with the ERA? That almost sounded like we were back to that discussion with Florence Kelly.
Great, so these are an excellent set of questions. I think with regard to strict scrutiny and intermediate scrutiny, that actually goes to the heart of what it means to make a transgenerational amendment. And part of the problem is that in the early 1970s, the advocates of the ERA said they wanted strict scrutiny. And they said they wanted strict scrutiny in part because they thought that strict scrutiny got rid of sex discrimination that mostly harmed women and was based on stereotypes about women. But fast forward, in the 1980s, strict scrutiny came to mean something different. Strict scrutiny came to mean scrutinize race distinctions like affirmative action intended to help the groups that have been underrepresented or disadvantaged or discriminated against in American society. So you have cases like Adirond in the race context, and even before that, Bakke, which eventually leads to a firmly established rule by the mid-1990s that race-based affirmative action gets strict scrutiny. And of course, the women who said strict scrutiny back in 1972 didn't know that strict scrutiny was going to become a tool of anti-affirmative action law. And I think that's precisely why Justice Ginsburg, when she authors United States versus Virginia, requiring the integration of the Virginia Military Institute, she actually was very careful not to talk about what she's doing as strict scrutiny. She drops a footnote to Adirond, and she carves out a space in the Virginia decision for gender distinctions that are designed to end women's economic disadvantage. She even obliquely references the CalFed case, which had to do with maternity leave, paid maternity leave, and unpaid maternity leave under California law, or under an employer's policy. So I think that the idea of intermediate scrutiny, or whatever you want to call it, it seems like the evolution since the 1970s of equal protection law has kind of changed what the project of the ERA is in two ways. One is that maybe we don't need the ERA to get us to intermediate scrutiny. And one of the things that Ginsburg said after the Virginia decision was that we have achieved through equal protection jurisprudence everything that the proponents of the ERA wanted in the 1970s. And that's true to some degree, It's not true to the extent that she herself, as a litigator in the early 1970s, was actually very interested in the problem of pregnancy discrimination. There was a case that actually could have been a Supreme Court case, but didn't become a Supreme Court case because it got mooted out. It was called Strzok versus Secretary of Defense. And that case was about an Air Force nurse who got fired for being pregnant. She was told that she should get an abortion if she wanted to keep her job, but if she chose to have the baby, she would lose her job. And Ginsburg believed that that was sex discrimination. She believed that pregnancy discrimination was sex discrimination, and they were getting ready to bring this case to the Supreme Court, but the Defense Department settled and gave the woman her job back. So we didn't have a landmark case-making opportunity to really think about the inequality of women based on their childbearing and child-rearing capacities as being an equal protection problem. And instead, later in the 70s, in a case about pregnancy benefits, or rather disability benefits excluding pregnancy, the Supreme Court actually says that pregnancy discrimination is not an equal protection violation. So this is just a longer way of saying that I think there were things that were intended by ERA advocates, including addressing inequalities that women face because they're mothers, that wasn't really completed by many of the achievements of equal protection jurisprudence that evolved after the 1970s. But that said, I don't actually think the strongest argument for the ERA is based on what it will do as law. Because what it will do as law depends somewhat on judicial interpretation, and one might argue that you could interpret the ERA in the same way that you interpret the Equal Protection Clause for sex purposes. So I don't think that the value of the ERA is really based on its fine-tuning of doctrine. I think we have some tools to fine-tune doctrine that already exist. But that said, I still think it's extremely important because I don't think that the Constitution is here just to fine-tune doctrine. I don't think that's what constitutional amendments are about. I think the Constitution is about the nation's identity. And I think the stories that we tell about the founding fathers and the values that are enshrined in the Constitution are as important to what the Constitution actually does as law. And I think here, it's just a fact that women have been changing the Constitution. They changed what the 14th Amendment means. They changed what the 5th Amendment means by bringing sex discrimination into the Constitution as a problem. And they did that in part because the movement for the ERA enabled them to do that. Arguably, without the movement for the ERA, you wouldn't have even have gotten the 27th Amendment in 1992. It's only because there was attention to what is the effect of time on amendments viability that the movement to start re-ratifying the 27th Amendment, not even really a movement, it was just one guy writing letters to state legislatures throughout the 1980s that ended up being successful. But he, by the way, the guy who started writing letters to state legislatures on the Congressional Pay Amendment throughout the 80s was originally writing his term paper about the ERA. And had he not been writing about the ERA, he never would have thought about, could we actually have an amendment that takes longer than 7 years, maybe 200 years? So I want to say that in many invisible ways, women have been changing the Constitution, and the failure of the ERA is basically a failure of our amendment process. It's a failure to recognize the invisible work that women have done. The failure to recognize women's invisible work is actually at the heart of what gender inequality in society and under the law is about. So I think that changing the narrative by way of this amendment is actually the most important reason why we really ought to complete it.
It would make us a more perfect union, maybe.
Yes.
Yeah, more transcendent document. And I worried out loud, and I think, again, that question that was posed, like what, in the hands of a currently conservative court, would they try to pull, the trick of, again, turning equal protection law against affirmative action, and therefore, let's say, asserting the rights of whites? So like you could imagine men invoking an equal rights amendment, I guess, under that parallel sort of analysis. But you wrote to me and you said I should not worry that much. And why don't you tell everyone what you said?
Well, I think that it's actually up to the American people now what this amendment means. And I think that is actually the beauty of a transgenerational amendment, because one of the things that you see when the amendment starts being ratified again in Nevada and Illinois and Virginia is that you have robust floor debates that bring the amendment into the 21st century, where women talk about why they are doing this. And it's clear that why they are doing this has everything to do with trying to address the remaining sources of inequality in American society, including the persistence of unequal pay and the concerns raised by the Me Too movement, and the inequalities that women face because they are mothers. Now, these are all things that I think would be helped by policy initiatives that might have to take gender into account sometimes, including, for example, a new statute in California that requires every corporate board of directors to have at least one woman, right? So it is a corporate board gender quota. That's actually being challenged in the courts right now in California based on equal protection. They're claiming the Equal Protection Clause does not allow you to make distinctions between women and men for the purposes of overcoming women's underrepresentation on corporate boards. And I do think that the opportunity to make new legislative history is a meaning-making opportunity for the people and our elected representatives. So it's not just the ratifiers in Nevada, Illinois, and Virginia, but also the folks in Congress whom we vote for, and 35 Senate seats are up for grabs. Well, grabs is probably a strong word, but there will be an opportunity to affect the composition of the Senate in November's elections. And I do think that Congress can decide, the Senate can decide, there are 48 co-sponsors now, as to whether the ERA deadline is going to be lifted. The House has already voted to do so, and when it voted to do so, it produced a report in the House Judiciary Committee and had hearings, and those hearings were an opportunity for legislators to say in the record that they're taking inspiration from constitutions around the world, that they think that disparate impact, which has not been recognized as a constitutional problem, should be recognized as a constitutional problem under the ERA. And I think the more we have opportunities for floor debates and hopefully hearings in the Senate, the more we have opportunities to say what we think the amendment should do. And different judges have different philosophies about the extent to which they should be looking at the framers' intent and legislative history. But I think many judges do care about legislative history. And I think if legislative history is created to make the ERA mean something other than the highly formal anti-affirmative action form of the Equal Protection Clause, then I think you will have an amendment that does a lot of things differently from the Equal Protection Clause. And then as a doctrinal fine-tuner, it'll actually be quite useful.
So I got a very specific question from one of my former students, which is, what do you anticipate to be the legal proceedings and outcomes following the recent claims of mass hysterectomies at ICE centers? Would the process be different if the ERA were law? And if so, what parts of the process would it change?
So I just think that hysterectomies, involuntary hysterectomies, to my mind, is a denial of rights that is gender-based. I can't really conceive of it as being a harm that is not gender-based, and it is being carried out by the federal government, by the United States. And so to me, that's an easy example of equal rights being abridged or denied, or both, on account of sex. So it seems to me that it's a constitutional problem. Having said that, I think that even without any ERA, we have provisions of the Constitution that could help attack those practices. But I do think that having an ERA that makes women's status equal and women's personhood more visible as part of the fundamental law can bring more political legitimacy to any efforts to do something about it and to find remedies for it.
And actually, your answer makes me think of another question, which is, I guess, at at various points, Ginsburg meditated, well, if only we had addressed abortion jurisprudence through the Equal Protection Clause as opposed to through, through privacy and due process litigation. Would there be any implications here again with the ERA passed for that?
Yeah, absolutely, because I think that fundamentally the framers of the ERA were concerned with women's inequality in society and the ways in which laws perpetuated that. And women's inequality in society has historically been justified because of women's role as mothers, both biological and social. Their capacity for reproduction has been fundamental to justifications for unequal rights. And I think that once we start thinking of that, then a broad conception of both reproductive freedom and reproductive justice become an important component of what it means to have equal status as rights bearers under the law. And I want to point out, though, that this is not just about abortion. It's also about the right to be a mother. And this is why a lot of the original framers of the ERA were so concerned with childcare. It was about the fact that it's actually not private. The choice to become a mother is not totally personal. It's something that has benefits to society. Women provide a lot of benefits to society when they do not participate in market work in order to raise the next generation. And those benefits, when we think about childbearing through the lens of privacy, including the choice not to have a child or the choice to have a child through the lens of privacy, it kind of erases all of the important ways in which childbearing is actually a public function for which there should be public support by way of public support for childbearing, as well as access to abortion, regardless of ability to pay.
Maybe just I'll combine one more question from the audience. It asks you to compare the cultural obstacles to ratifying the ERA now versus in the 70s or the 60s and the 70s, and making that comparison. And I guess, reading the book, one can't help but be struck by how it's a very positive story at the end. You're very optimistic about the women who are doing the work in Virginia and Nevada. Maybe you can talk about the forces who are trying to stop it and why you think legislators today are actually succeeding.
So I don't think that the cultural obstacles are that great today. 75, there have been several polls that have been conducted that suggest that 75 to 80% of the US public supports the ERA. There have been other interesting polls that suggest that many people believe that we already have an ERA in the US Constitution, even though we don't. So I think that generally, most people are in favor of having a constitutional guarantee of equality in the US Constitution. I think the primary barrier is procedural. So some people are concerned that allowing ratification so many years after it was originally proposed produces the legitimacy problem that we discussed earlier. So some are proponents of, if we really want it, maybe we should just start all over again, right? There are, to the extent that it's been opposed, both in the state legislatures in recent ratification debates and in Congress on the deadline extension or the deadline removal proposals, the main opposition has come from those who believe that the ERA could be interpreted to require access to abortion on demand under all circumstances. And I think that on the one hand, as I was saying earlier, it's hard to think of equal rights without thinking that women's reproductive freedom and some measure of reproductive freedom has something to do with women being equal in society and under the law. But that's not the same thing as saying every abortion right imaginable will be protected by the amendment. I think that's something that has to be worked out in the future. but certainly fear of an expansion of abortion rights has often been used as an argument to get people scared about what the ERA might do.
So I think that we're just at our time limit, and again, I just had such a wonderful time talking to you about this terrific book, Julie. Thank you for again involving me with this. It's on sale. You can get it, and again, it populates, I think, the 20th century with people who maybe you know a little bit about, and it kind of creates a narrative and a connection between them, working generation after generation towards this goal that seems to be on the brink of succeeding. Thank you, Julie.
Thank you so much, Irv. It's been such a great conversation. I really appreciate it.
And thanks to everyone who came. Thanks to all the Hunterites who came, especially my students. All right, have a good night.
Before we say goodbye, on behalf of the association, I just want to express our heartfelt thanks for spending your very busy day, part of your very busy day with us today, Julie. And I ignored to mention that Julie was actually Irving's student, so it's fascinating to see student and teacher coming back together in such a fascinating environment as the Hunter community. And thank you so much for your time and devotion and spending an hour with us today. And everyone else, thank you so much for coming, and sign up for our other events as well, because we have a lot of very interesting events coming up. Thank you so much, everyone. Goodbye.
Thank you, Enrico. Good night.